REG Area II tests whether you can apply business law rules to scenarios involving agents, contracts, creditors, federal laws, business owners, and legal entities.
The main skill is identifying the legal relationship, the rights and duties of each party, and the consequence when something goes wrong.
So business law makes up about 15 to 25% of the REG exam. And you know, this area is uniquely fact-pattern driven. You aren't just going to be asked to recite definitions. Instead, you'll be required to perform objective scenario analysis based on general U.S. business law principles. For every multiple-choice question you face, your job is to identify the parties involved, classify the legal issue at hand, apply the correct rule, and then make a precise legal determination. Approach every single scenario knowing that you are always solving for one of four specific outcomes: liability, enforceability, priority, or remedy.
Let's dive into our first major grouping, the principal-agent relationship. Now, notice the strict differentiation here between actual and apparent authority. Exam questions typically ask who is legally bound by an agent's actions, and to answer that, you really have to trace the authority. Actual authority is exactly what it sounds like. It's what the principal expressly or impliedly grants directly to the agent. Apparent authority, on the other hand, actually has nothing to do with what the principal told the agent. It's created entirely by the principal's words or conduct toward a third party, which leads that third party to reasonably believe the agent has authority. If either type of authority exists, the principal is legally bound to the contract.
Okay, beyond authority, you've got to understand duties and disclosure. Agents owe duties of care, loyalty, and accounting to their principals. Principals, in turn, owe duties of compensation, reimbursement, and indemnification to their agents. Now, what if an agent acts completely without authority? Well, a principal can actually still be bound if they later ratify the unauthorized act. And this usually happens by accepting the financial benefits of the deal with full knowledge of the material facts. The absolutely crucial point in these scenarios is determining liability based on disclosure. If the principal is fully disclosed to the third party, only the principal is liable on the contract. But if the principal is partially disclosed, meaning the third party knows an agency exists but doesn't know the principal's exact identity, or if they're entirely undisclosed, then the agent becomes personally liable on the contract right alongside the principal. Though it's worth noting the agent can later seek indemnification.
Moving right along, let's transition to our second group, contracts. To approach contract scenarios systematically, you really need to follow this strict chronological life cycle. It's like a mental map. A contract always begins with formation. If it's properly formed, it moves to performance. Once performance is complete exactly as agreed, the contract reaches discharge. But if performance fails or falls short, you've got a breach, which leads directly to evaluating remedies. When you're reading a fact pattern on the exam, place the scenario exactly where it belongs on this timeline. Doing this ensures you don't accidentally apply a remedy rule to a formation problem.
At their core, contract questions are fundamentally asking whether an agreement exists, if it's legally enforceable, and what remedy applies if there's a breach. For a valid contract to be formed, you need an offer, an acceptance, and consideration, which is defined as a bargain for exchange of legal value. On top of that, both parties must have the legal capacity to contract, and the underlying purpose of the agreement has to be lawful. But even if all these foundational elements exist, valid defenses like fraud, duress, or mutual mistake can make the contract void or voidable. If a valid contract is breached, you've got to determine the appropriate remedy. Usually this means monetary compensatory damages to basically make the non-breaching party whole. However, in cases that involve unique property, an equitable remedy like specific performance might apply instead. That's where the court literally forces the party to fulfill the exact terms of the contract.
Our third area is debtor-creditor relationships. This section really highlights the critical difference in financial risk. Secured creditors hold a direct legal claim against specific collateral. Think things like business equipment, inventory, or a vehicle that explicitly backs the debt. Unsecured creditors, on the other hand, have no collateral. They rely purely on the debtor's general promise to repay. Exam scenarios here are going to focus heavily on identifying who has the right to repossess property, who faces liability upon default, and, most importantly, who has legal priority when multiple creditors make claims on the exact same asset.
To solve secured transaction priority disputes, you have to systematically evaluate attachment and perfection. Attachment happens when a creditor gives value, the debtor has legal rights in the collateral, and an authenticated agreement is made. Basically, attachment gives the creditor rights strictly against the debtor. Perfection, which is most often achieved by properly filing a financing statement with the state, is the critical legal step that establishes the creditor's priority against third parties and competing creditors. You also need to be ready to apply the rules regarding guarantors and sureties. These are the folks who promise to pay if the primary debtor defaults. And finally, you must understand the basics of bankruptcy proceedings. Specifically, you need to know the high-level rules governing how limited property is distributed among competing secured and unsecured claimants during a liquidation.
The fourth group covers federal laws and regulations. This area requires a really solid, high-level map of compliance and statutory obligations. You'll definitely be tested on a business's employment tax responsibilities and the legal distinctions used to classify a worker as an employee versus an independent contractor. And remember the golden rule there. Control over how the work is done is usually the deciding factor in that classification. Additionally, you'll need to navigate the mandates of qualified health plans under the Affordable Care Act, high-level bankruptcy concepts like which specific debts cannot be discharged by law, and the Foreign Corrupt Practices Act, or FCPA. The FCPA strictly prohibits making improper payments or bribes to foreign government officials just to obtain or retain business. For the exam, focus heavily on how misclassifications or compliance failures generate legal and financial liability in the fact patterns.
All right, our final group is business structures. Looking closely at this comparison, you can evaluate the major entity types across three critical dimensions: formation, owner liability, and management authority. Notice that sole proprietorships and general partnerships require absolutely no formal state filings to form. But the trade-off is they expose their owners to unlimited personal liability for the business's debts. Conversely, limited partnerships, LLPs, LLCs, and corporations do require formal state filings to be legally recognized. The upside? They generally offer limited liability protection, which shields the owner's personal assets. Management authority also shifts across these entities. It goes from direct, unilateral owner control in a proprietorship to equal control among general partners, all the way to a highly centralized board of directors in a corporation.
Beyond just formation, you really must evaluate other key entity characteristics. Ask yourself, how easily can ownership interests be transferred to a third party? Does the business have continuity of life, or does it dissolve automatically upon the death or withdrawal of an owner? What specific fiduciary duties of care and loyalty do the owners and managers owe to the entity itself? And finally, you must master what is probably the most crucial distinction you will face on the exam in this area. A business's legal entity status under state law does not automatically dictate its federal tax classification. Let me give you an example. Forming an LLC provides the legal structure of limited liability under state law. But for federal tax purposes, that exact same LLC could be treated as a sole proprietorship, a partnership, or even a corporation. So never conflate state legal structure with federal tax treatment.
To synthesize all these disparate rules, I want to introduce a 6-step cognitive checklist. Think of this framework as your repeatable methodology for tackling multiple choice questions. Step 1. Who are the parties? Step 2. What legal relationship exists between them? Step 3. What specific authority, duty, right, or obligation applies? Step 4. What exactly happened in the fact pattern? Was it a formation issue, a breach, a default, a compliance failure, or some kind of misconduct? Step 5. Based on the legal rules, who is bound, liable, protected, or prioritized? And finally, Step 6. What exact remedy or legal consequence follows? Let's go ahead and apply this framework to a few quick scenarios.
Here is scenario 1. Let's say an employee signs a standard vendor contract on behalf of their employer without explicit permission, but the employer routinely allows this conduct. So, who is bound? Using our framework, let's break it down. The parties are the employer, the employee, and the vendor. The relationship is principal and agent. The core issue here is authority. Because the employee lacked explicit permission, there's no actual authority. However, because the employer routinely allows this conduct, which creates a reasonable expectation for that third-party vendor, apparent authority absolutely exists. Therefore, the legal consequence is pretty clear. The employer is firmly bound to the contract.
Moving on to scenario 2. A buyer offers $5,000 for equipment. The seller responds, "I'll take $5,500. The buyer walks away. The seller then demands $5,000. So, is there a contract? Let's run the checklist again. We have a buyer and seller in a contract formation scenario. An initial offer of $5,000 was made. Now, the response of $5,500 wasn't an acceptance. It was actually a counteroffer. And the legal rule here is that a counteroffer completely terminates the original offer. Therefore, when the seller later demands $5,000, there is simply no existing offer left to accept. The consequence? No enforceable contract was formed. All right, let's look at scenario 3. A debtor defaults. Creditor A has an attached but unperfected interest. Creditor B has a perfected interest. Who has priority to the collateral? The relationship here is between competing secured creditors.
The applicable rule dictates that perfection establishes priority over an unperfected interest. Even if creditor A attached their security interest to the collateral first, their failure to perfect leaves them legally subordinate. So the consequence is that creditor B, the perfected creditor, holds priority and is legally entitled to satisfy their debt from the collateral first.
As we wrap up this foundational map, you must be hyper-aware of these common exam traps. Candidates frequently lose points by confusing actual authority with apparent authority, or by completely missing the fact that a principal later ratified an unauthorized act. Also, do not assume every promise is an enforceable contract. You have to actively look for consideration, and never ignore valid contract defenses. In debtor-creditor scenarios, meticulously separate secured from unsecured priority and make sure you remember the specific conditions that trigger a guarantor's liability. Finally, do not mix up owner liability rules across different entity types, and remember the absolute golden rule we discussed. An LLC's legal status does not determine its federal tax treatment. Maintain a controlled, objective approach to these mechanics, and you'll be in great shape.
Area 2 is a relationship and consequence area. First, identify the parties and legal relationship. Then classify the issue, apply the rule, and determine who is bound, liable, protected, prioritized, or entitled to a remedy.